they are finding that they have ideas that are going to best get out there through being in charge of things themselves, or that traditional employment is stifling their creativity or limiting their potential, or is otherwise just not a great fit. So a lot of it comes around of being able to meet your own potential, fulfill your own goals. I always want to thank of course, the City of Columbus, which has always been a great friend of our program at the Legal Aid Society of Columbus, and also the big sponsors that we have, without which we could not do any of the work we do. I'm Paul Bryson. I'm one of the staff attorneys here. I spend about 90% of my time doing our small business and nonprofit work. And joining me today is Selena Bontigao. She is a joint JD MBA, so a joint law and business student at The Ohio State University, who has been working with me and doing wonderful work. And I thought that she would add a lot if she presented with me today. So thanks for being here, Selena. And I'm going to turn over to you for the next couple slides.
Perfect. Thank you so much, Paul. And again, my name's Selena Bontigao, and I came to law school essentially because I wanted to be a part in helping small business and start small business. My mom is a business owner, so I'm really glad to have this opportunity to be able to do this presentation. So today we are just going to go over the do's and don'ts of an LLC and what you can that could help you in pursuing more of your goals. And so just a quick overview, an LLC stands for a limited liability company. And essentially it is a legal designation that allows you to distinguish between your business assets versus your personal assets. It's a legal protection that provides also less complexity and less formality. So for example, say, as opposed to an S Corp or a C Corp, an LLC allows you with more flexibility when it comes to managing your business. And it also draws from partnerships and corporations, and of course can be for-profit and nonprofit. And this is also stems from statutory law, the state law. So if we go to the next slide, we'll see that the law on LLC specifically for Ohio is on Ohio Revised Code 170548. And we mainly want to focus on that second or subsection B. And if you see there, it says no member, manager, or officer of a limited liability company is personally liable simply by being a member or a manager or an officer of an LLC. That essentially gives you that protection and says that just because you are the owner of an LLC does not automatically mean that you're personally liable. And we call this an imperfect shield. And that's what we're going to be going over for most of this presentation. And essentially, members are only limited by their risk, by the risk that they have invested within the entity. And the purpose of this really, and why LLCs are created and allowed by law, is to spur investments and to encourage economic development. And so as Paul had mentioned earlier in the opening, is to allow you to really make the most of your ideas and your goals in your life. And the effect is to allow you to start a business without putting your house, your car, retirement, bank accounts, and any of your personal assets on the line. And so for the next slide.
Yeah, I'm going to bust in for one moment here. I know that there are some people who may be watching that are thinking, well, I formed a corporation. We're focusing on LLCs in this presentation because it's the most common vehicle for people with small businesses, but limited liability in LLCs borrows completely from corporations. So the things that we're talking about are actually just as far as limited liability, are just as true about corporations as they are about limited liability companies. So if you've got a corporation, not an LLC, these things are still relevant for you, still important for you. We just tend to talk about them through the LLC context, because we find that that is what most people have.
And then thank you, Paul. And then like I said earlier too, it tends to be that we talk about LLC because it not only this what most people have, but it also allows that flexibility and structure. And so the three tiers of protection that we wanted to concentrate on is the formality, capitalization, and use. And again, having that LLC designation or whether corp designation allows you to protection from your personal assets versus the business assets. So that first formality part, if we go on to the next slide, is picking your name. Your name, when you want to form an LLC, must be distinguishable from others. Now, what does distinguishable mean? Well, it just means that you have to make sure that that name is not something that has been previously registered with the Secretary of State. So not a similar name for a corporation, another LLC, or a trade name previously registered. And if you go to the Secretary of State website, they actually have a tab that indicates more documents on rules on what counts as distinguishable. So, for example, having Mr. and spelling out Mr. Coffee LLC is not distinguishable from using the MR period. So, something like that. And then they also have rules and extra notes when it comes to using foreign languages or what names and words are unacceptable for an LLC. The second part is that name must include some indication that the designation is an LLC, so adding LLC at the end of the name or LTD or limited. And finally, you can hold a business name through the Secretary of State website for $39. So that's not registering your actual LLC yet, but just merely holding the name.
That's if you've got a name that you think is just the best name in the world and you're worried somebody else is going to take it before you get everything else sorted out. That's a way that you can preserve that so somebody else doesn't take it. There is a piece that I have not integrated into this yet because it's brand new law. So in the past couple of years, the United States Supreme Court has decided two cases about trademark and the First Amendment and profanity, obscenity. So currently, our Secretary of State here in Ohio says you can't register a name if it includes profanity or obscenity. There is kind of a legal cloud hanging over that with the trademark decisions that the United States Supreme Court has made in the past couple years. There was an Asian American band that had a name that was also a word that is used as a slur for Asian Americans and for Asian Pacific Islander people. The Supreme Court said that the First Amendment did require that they be allowed to register and trademark that name. And then there was a clothing company with a name that sounded, it was FUCD was the name of that clothing company, and the Supreme Court held the First Amendment required that the trademark, the United States Patent and Trademark Office allow them to register that name as a trademarkable name, even though there was that ban on profanity or obscenity. So that is something that if it really is important to your business, you may want to consult with a lawyer about whether a legal challenge to that restriction by the Secretary of State is something that you want to go through. I think there's a legal cloud hanging over it. We don't often in the business law world deal with those super hot new issues that come out of the United States Supreme Court. So I always like a chance to talk about like the cool new developments when it comes to that. But maybe you don't want to spend the money fighting a case all the way to the United States Supreme Court with the Ohio Secretary of State, because that might be bad for business. And so maybe you just go another way with your name.
And onto that, you could also always check the website. They have a quick search box to see what names are already taken And that's just a quick way for you to kind of see which ones are already registered and taken before you go and hold your business name. And then for the next slide, another thing when it comes to formality, and again, that protection is having a statutory agent. Now, most small companies have the owner as their agent. But essentially, an agent is a person or a corporation that is able to take on and receive legal documents for the business entity. So that agent has to sign the articles of incorporation when you go and register for the LLC and be able to accept, again, legal documents. Now, if you choose to hire an agent, you have to make sure that you keep them current and you pay your agent. So if anything, like you change a business address, make sure that the agent knows, so that again, that legal process is ensured that they've is received properly. Anything on that?
I guess we forgot to mention, if anybody has any questions as we go through here, we're happy to answer questions at the end. If you want to throw them in the chat, that'll create a good log for us as we're going on. But if you want to ask stuff at the end, that works too. You know, next, the kind of the last piece of formality, we like to think about these kind of barriers that protect your limited liability as a series of walls. And you want to put up as many walls as possible between you and the people that are trying to get at your assets. And so the last brick in that formality wall is the operating agreement. An operating agreement is basically a contract between the LLC and its members, all as a group, that dictates how everything's going to work. I like to think about it as having all the arguments before you get started. The biggest arguments in business, when you've got business partners, is who's in charge of what, who gets paid what, you know, what you're allowed to do, how the money's going to go, and all those things. The operating agreement is a way to step-by-step figure all that stuff out, so that when you're operating your business and you're doing your day-by-day, it's clear. You go back to the document, you read it, you know how it works out, so that you're not fighting about it. You're not spending time and money fighting about it, and instead you're spending time and money making money, which is what you got into business to do. I wish I could tell you that there was a operating agreement that you could just go out and download from online and it would be great and good. There isn't really, and that is because operating agreements have some provisions that the law will fill in if you don't have an operating agreement. You know, for example, people will get money out of an LLC in proportion to their ownership. If you don't have an operating agreement that says otherwise, that's one of the things that's in the statute. But those kind of are gap fillers that say what happens if you don't have an operating agreement. There aren't many times that you get to create the law that applies to you or your business. Normally, you're stuck with whatever law exists, and an operating agreement is a time that you get to create some of that law. So, you know, take advantage of it. They aren't required to be filed. It's not going to be on record with a government agency or anything. That does make it harder to find good examples. This is something where getting a lawyer is really helpful, but it should exist, and that is for a couple reasons. One is because you and your partners, you've figured this stuff out and you've got it in writing. The other is, even if you're a sole proprietor, even if you're the only member of this LLC, if you go for a loan, one of the things the loan underwriters are going to want to see is going to be your operating agreement. And anytime you're dealing with any kind of underwriter, it's all about checking off their boxes. And if they've got a box unchecked that says operating agreement and you can't cause them to easily be able to check that box, you run the risk of not getting that loan. And so it's really a good idea to have one in place, even if you're the only member. It'll cover, you know, several topics. These are the things that are most common. You know, what's this LLC do? who has what rights, how are you distributing money, how often do you have meetings, do you allow new people to buy in, do you allow new investors, do you restrict that some way, do you have to have everyone approve if there's going to be a new investor? If someone goes to leave the LLC, what happens to their ownership? Do the other owners get a chance to buy that, or can somebody just sell out to a stranger? That matters a lot in these smaller held companies. What do you do if there's a dispute? You can have in an operating agreement that instead of going to court, it has to go to an arbitration or a mediation. Sometimes, to keep things private and to maybe lower the costs of those. And when does this thing end? Can there be something somebody does that makes this company dissolve, that makes this company go away because it's no longer viable? Or are you only doing this for a period of time, 10 years, instead of, for the rest of time? So it lets you designate all of those things. It's not set in stone. If the members agree, you can change your operating agreement. You can update it over time, but having it at the beginning solves a lot of potential problems down the road. And it's assigned to a court that is looking at maybe deciding whether you get to be personally liable, whether you're personally on the hook. It's assigned to a court that the LLC is really real, that it really exists, and that it should be respected, and maybe not put through. So it's another brick in that wall. And then the final, part of some of this formality, pay attention to how you're contracting. You should be entering into contracts with vendors in your LLC's name, not your own name. Now, this might be difficult. As a new business, almost every vendor you deal with, lenders, suppliers, all of those things, are going to want you to also sign in your personal name because your business doesn't have any credit yet. But to the extent you can, all of your contracts that you're in should be by you as a member of the LLC or as the authorized signer for the LLC, not just your name with nothing else with it. And the reason for that is then it's clear that it is your LLC that's entering this contract, not you. And that protects you by making it clear to a court that everyone involved in this deal knows that they're dealing with a limited liability company or with a corporation that has limited liability, so that it makes it harder for the court to say, well, you are personally on the line for this. And it makes it hard for another side to prove that. You've probably at this stage done your filing. I mean, most of the people that we end up finding in these presentations have already done their filings with the Secretary of State because it is so easy. So I don't think this is going to be new to you, but corporations, LLCs, they've got to get registered with the government through the Secretary of State's office. There's a $99 fee for that the Secretary of State charges. You may have done a paper application. They still take the paper applications. That's fine. It is way easier to do the electronic one. The information on the paper and electronic ones is exactly the same. It's just a matter of whether you type it into the electronic database or whether you mail it in. I like the electronic because it's faster. Frankly, you get your response in what you used to have to pay extra money for to get expedited if you mailed it in. So for any of us old dogs who knew what it was like to send it in and have to wait a week until you found out if you were registered, and then maybe your clients would need to pay extra money to find out sooner, the electronic submission is still pretty cool. But paperwork's fine too. And in fact, I like to fill it out on the paper so I can go through it with somebody easier and then put it in electronically if I'm doing it for someone.
Okay, so the second layer that we're talking about when it comes to, again, just protection for you is capitalization. And so just as Paul had mentioned, just having these things is just a way for you to show and for the business to show in a court that you have been planning and preparing to take on liabilities as a business, and take on expenses as they come. So one way you could do that is ensuring that business assets are under business names. So not only when you form contracts and when you're contracting, but also in anything that you do, try your best to have everything under the business name. And then a second thing that you could do is ensuring that documents flow, the documentation and flow of money and assets are specifically documented. It could be as rudimentary as using an Excel spreadsheet. I love Excel because it's so powerful. Or having a specific software like QuickBooks to maintain records of those assets, and again the flow of money. And then lastly, getting an insurance for the company. And again, it's just ensuring that you show to the court that you are respecting the business as a separate legal entity from your personal assets.
And I
That's
always
just,
like to go into a, oh, sorry, Selena, I
oh
didn't
no,
mean to talk over
you're
you.
fine, you're fine. I was just gonna say it's just that again added layer that helps distinguish between your personal assets and your business liabilities.
I like to go into a little detail here about when my business that I've owned. This can be difficult, especially for a new business, because when you first start up, maybe you're using a computer that has been your personal computer, and now you're doing business with it. Or you find it with cars sometimes, that this is my personal car that I make a lot of business use out of. Or you find, the money, my only money is the money that I make through my company, and I'm the only member of my company. Why can't I just write out my rent check or my electric bill, out of the business account? And that it gets difficult. But the way that we always want to look at capitalization is everything is fine until there's a problem or until somebody else starts looking at it. When you're talking about your limited liability, the situation where it really matters is when somebody has already pulled you into court, and now the other side and a judge are looking at your business, trying to figure out if there's a way that the other side gets to get to you through it. And so the best way to protect that is to set up procedures and make sure you use them. So when I ran my business, there were times that I would go, man, electric bill is coming due. I haven't paid myself yet. I had better make sure that I write myself a check now for my normal pay, so that money is in my personal account to write my electric bill out of. Even though I got a million other things to do today, and it's very inconvenient for me to go to the bank and deposit that. If it's clear on a paper record, if somebody hires an accountant to go through it and try to prove that I've been doing the wrong thing, then it is crystal clear that I'm doing the right thing at every point. It's one of those things, a police officer drives past you and all of a sudden you're at 10 and 2, and you've put down your cell phone, or you're not taking a drink of that coffee anymore, and you're locked on, you're making sure your lights are turned on and everything. It's kind of like that. You want, if somebody else is looking, to have everything be clear. And if you're low tech, it really can be as easy as you keep a written log. Whatever way you keep your business records is fine, as long as you're consistent with it, and as long as you can tell what those things are. So you can start with, a paper ledger as you begin, and then you find out, oh, this business is really doing well. I can afford QuickBooks now, or I can afford a bookkeeper, and transition it over. There's nothing wrong with doing that, as long as you do the thing that you've set yourself up to do. And maybe you look at, my computer, I don't use it for home anymore. This really is just my business computer. And you write out for your corporate records that one of your capital contributions to the business is this computer that is, it was probably $800 when you bought it, but now it's 2 years old, so maybe it's $100. It's a small capital contribution. And then you go in and you change the owner in the computer, to being the business instead of you. That way, it's just clear. It's little things like that end up making a lot of sense. And then about insurance, that's always something I tell people, talk with your insurance agent about. If you are doing business out of your home, your homeowner's insurance is almost certainly going to have an exclusion in it that says that it doesn't cover things that you're doing that are part of commercial activity. So you can talk to your insurance agent and say, I'm running a business out of my home. I have customers that come sometimes, or I keep some business equipment there. I want to make sure it's covered. And they can give you quotes for adding a rider so that your business is covered. Finding out that you don't have insurance coverage for something that happened after it happens is a really terrible surprise. And it's one that you don't want to have to deal with. So knowing that exclusions exist, part of the business model of insurance is only covering exactly what they say they cover, and making sure that they have pretty much excluded anything else, unless they charge you money to include that, is just the way insurance works. So the good thing is, for small businesses, most agents are very conversant with how to add those riders to your existing policies, whether it's home, or whether you use your personal car to do all your business too, covering that. So if you are doing a business run and you get in an accident or something, you make sure you don't lose out that coverage, because insurance pays for a lawyer to defend you and covers losses. And you don't want to lose out on either one of those things because they're very expensive. That's enough hijacking by me, Selena.
No, you're fine. And then thank you. And it seems like a bit of repetitive, but we just want to make sure, again, that last bit of protection that we're going to go over is the use. Like Paul said, consistency is key. It seems like these procedures, um, uh, it's as you use it as much as you can because they're there for your protection, so much so. So for example, when we're talking about use, it's that alter ego, making sure that the business isn't just another entity like a holding for your income or whatever, that it is an actual legal entity, and you show that but by following the procedures that you've made when you're when you're filing your registration, and also by capitalization. So one way that you could do is making sure that you use your EIN. So anytime you use, like earlier I said, make sure you use your business assets under your business name. Using your EIN is another way for you to avoid that alter ego liability, and making sure that you file the proper tax returns for the business entity. And then the biggest thing that we want you guys to get out of, if anything, this session is don't use personal assets for business, and then don't use your business assets for your personal use. And then that operating agreement is just another layer of protection, and following those procedures will ensure that to the court, when they're looking at your files, they know that it is a separate business entity from your personal accounts and your personal assets. And then lastly, usually designating a managing member, and going through that manager also helps to maintain another separation and another layer of protection.
It also helps because, and my family runs like this, my spouse and I run things this way. You don't want two people out there doing completely inconsistent things, especially if it's all coming out of one checkbook. So we handle things with one of us, pays the bills, and the other just checks in with the other to make sure that the bills have been paid. That way, I'm not writing out a check for the rent, and my spouse isn't writing out a check for the rent, and one of those is going to bounce, and all of a sudden we're out of money, or something like that. So having that managing member be the one who does that business and just has to report out, is good to make sure that you've got one hand on the steering wheel, really. I mean, just trying to direct that. Um, it also takes advantage sometimes of people's skill sets. Maybe you've got one person who is great at marketing, and should be out there drumming up new business and making those connections, and another person who's really good with the numbers and making sure the budget works. So it also takes advantage of people's skill sets, and that's probably why you've got a business partner, is the two of you work really well together. So that's a wonderful way to take care of that and manage that. The last thing I always like to remind people of is all the limited liability in the world can't help you if you're the one doing it. Um, this was especially true for me as a lawyer when I had my law practice. There's on top of this thing I call the my own hands rule. It's also enshrined in state law that lawyers are not allowed to um, kind of negotiate away or get rid of their professional liability for malpractice. So even though I practice law through an LLC, if I screwed up on a case and somebody sued me for malpractice, I was going to be on the hook for it. And I couldn't get rid of that. The way this comes in for most other small businesses is, say you're Selena's Fencing, and you put up fences all over the place, and you're the person that goes through and actually pounds all the stakes in for the fences and screws the rails to them. When it comes to your suppliers that you're buying wood from and everything, your limited liability is going to be fine as long as that's in your contracts. But say you're out on a job site and you're putting up a fence and you go, oh man, it's a hot day, and you lean against it and the whole fence falls over with you, and there's a kid on the other side and you kind of squash them and their parents get mad. You did that. You were actually the one there taking the action. So they may be able to sue you personally for your personal conduct. And the fact that you have an LLC isn't necessarily going to save you from that. I like to say that not as a reason to scare anybody, but because I don't like surprises. And so it's good for somebody to know that you are still responsible for the things that you're out in the world doing personally, even with limited liability. The other way this comes in, and actually this is far more common, is with a personal guarantee. So I'm going to pick on Yellow Pages because they certainly don't still do business under that name anymore, and maybe I'm picking on a business that's not going to be able to call me out for having picked on them. But it used to be that you'd sign up for, I want to have an advertisement in the Yellow Pages, and they'd sign you up for a renewing contract. And eventually you'd go, man, I'm not getting any calls. I don't want to have to pay for that anymore. And it was hard to cancel that, and it was hard to get out of it for different reasons. They would almost always have all their salespeople also have the business owner sign a personal guarantee on those contracts, so that you couldn't just stop paying it and go, ha, you can only sue my business, you can't get to me. They would have you sign that personal guarantee so they could get to you, because most small businesses, when they first start existing, they don't have any credit. They've never done anything. You were formed yesterday. You've got no credit reliability to trade on. So they want the owner to also sign for it. If you've done one of those personal guarantees, you are also on the hook. They can garnish your wages from something else, or put a lien on your house, or things like that if you've signed one of those personal guarantees and they sue you on it. Personal guarantees aren't a don't do this deal. Sometimes they're necessary, but they are a time when you want to know what you're doing, and know what that personal guarantee means, to make sure that that deal is worth it for you. Because the Yellow Pages ads, I'm picking on them, but if they generated business for you, and in some industries that was the way to get leads that were not the word of mouth ones, you could say, you know what, personal guarantee, that's fine. This is how I'm going to get people in to pay me. I'm okay if I'm on the hook for that. But maybe you didn't want to do that for a riskier deal. Um, And you probably should know that so that you can propose that as part of negotiations. Yeah, I'll do this deal with you, but I'm not signing that personal guarantee because you know what it is. And a lot of times the salesperson doesn't know what that personal guarantee is about. They just know they're supposed to go back with all these boxes signed. And so they'll tell you, sign these 4 places and we'll get this deal done. And it'll be a wonderful deal. This will help you make plenty of money. But you can at least look at it and decide with an informed view whether it's something you really want to do. And it may be that it's not absolutely necessary for them to come back with that personal guarantee signed. But you'll never find out if you don't say, no, not that. Go ask your supervisor, what I can do to not have to sign that. The last one is it's good to be the people that make the rules. So for taxes, the government will always have you designate a responsible individual. That's one of the lines on the EIN. It's one of the things you fill out when you get a vendor's license for sales tax. The responsible individual is personally on the hook for those business taxes if they don't get paid. So payroll withholding for your employees, if you collect that and you don't pay it to the government, they can come after the responsible individual. And it doesn't matter if there's a corporation or an LLC involved. And sales taxes, they're going to come after the responsible individual if those sales taxes don't get paid. So that's an important thing to know. I've had people say, well, but that was my business. How can they come after me? Well, because they're the government, and they wrote the law, and that was how they wrote it. So you should know that if you're going to be dealing with them. It's okay to be Steve Urkel and say, did I do that when you think it may get you out of something? But you shouldn't ever go, wait, did I do that? You should know what you're out there in the world doing. My name is Paul Bryson. I'm a staff attorney at the Legal Aid Society. About 90% of my work is doing small business, nonprofit kind of things. That's my direct dial there. So you can always call me. I may end up saying, hey, I got to have you route back through intake so that I have you fill out the paperwork we need people to fill out before I can give them legal advice. That way I don't get into trouble with my boss. But I do love to talk to people and sometimes can do legal information before then. And so you can call me, you can email me. I'm fine with that. I see a couple friendly faces on the call there. I'm going to take a peek at the chat and see what we've had. The main thing in the chat that I saw is a good note from my friend Ambrose Moses, who's out there. Hi, Ambrose. And yes, there is a new LLC code. It goes into effect in 2022, so I haven't changed my sites to it yet. But Ohio has written a brand new limited liability company, part of the revised code. It is mainly the same. It adds a few details that I think only lawyers really are going to care about. One of the things that it does make specific is if you don't have a statutory agent for your LLC, or the Secretary of State finds out that your statutory agent is no longer serving. So maybe the Secretary of State tries to send out mail and it comes back as, not at this address from what the company you've paid to be your statutory agent. Then your LLC can be canceled, which means it doesn't exist any longer, which means that you don't have limited liability any longer. So that is definitely a reason to make sure you keep that updated. You only have to update it if it changes. So if you change your statutory agent or their address changes, that's really the only time you have to update it. I see this a lot in the litigation parts of my practice. I'm also a bankruptcy lawyer. It's only a little bit of what I do now, but I used to do a lot of it. And in bankruptcy, you're sending notices to lots of companies because your clients owe lots of people. Most of us do. And one thing that always frustrated me was there are a bunch of companies in Cleveland that are basically just professional statutory agents. They don't do anything but accept mail for other companies. And so they'd be the registered agent for, some company that my client owed money to. And so I'd send them a notice of the bankruptcy and it would come back not at this address or undeliverable. Well, how could it be that your statutory agent that's listed with the Secretary of State isn't accepting mail for your company anymore. And I found out it's because they weren't getting paid anymore. That company didn't pay them to be the statutory agent, so they said, I quit. But the Secretary of State's records were not updated. So I was still sending things there. The bad part about that for your business, while it was an annoyance to me, it wasn't a problem for my client because they still sent it where it was supposed to go. It was still good notice to the company, but the company didn't have any clue about it. And I certainly don't want you or your business to be in that situation where you've been sued and somebody sent the notice of the lawsuit to your statutory agent who didn't accept it, didn't send it to you because you haven't been paying them. And all of a sudden, you've been served under law and somebody can get a judgment against you and you don't have any idea about it. That is a terrible situation to be in. So on top of the ability for the Secretary of State to cancel your filing to get rid of your LLC that way, it's also just good business. If you're gonna get sued, if you're gonna get some kind of important mail that comes to your statutory agent, you want to get that and you want to get it quickly. As another example, I have a current client who they found out their statutory agent was somebody they didn't have control over. It was just a person who lives at the who uses the place that they do business, and who was there all the time. But he wasn't somebody. He wasn't an employee. They didn't have a contract with them or anything. He didn't give them some mail for more than a month. And when they finally got it, they opened it, and it was from the unemployment system here in Ohio, and said, "This person has filed a claim saying that they're one of your employees and that they don't work for you anymore, and they filed an unemployment claim, and you need to respond within 15 days." Well, their response time was over, um, and so they were left scrambling. Oh gosh, what do we do? Does this mean our unemployment premiums are going to go up? Because, in a surprise to everyone, the person who had said they worked there and got laid off was not anybody they knew anything about. It was a completely fraudulent unemployment claim. But they were really, really scared that their premiums might go up or they might be out money because of this fraud, because their registered agent just flat didn't give them their mail. Because those timelines can be really harsh sometimes. Now, I think we're going to work that out because thankfully there's been enough unemployment fraud that the unemployment people are being a little, more flexible about that. But some of those things are not flexible, and so you really want to know. We have some more time that we have available if people have questions. I have been told that I need to learn when to stop talking, but I don't. I'm not in a hurry to. And Selena has some good experience and expertise that she can share too. So if anybody's got any questions, you can throw them in the chat, or if you're able to unmute yourself, that's okay too. Okay, I don't see any questions coming in. So before we get done with our time, I do want to make a plug real quick for and explain our eligibility and the way things can work if businesses want to see if the Legal Aid Society of Columbus can represent them. So let me go ahead and close the slideshow, stop my screen share so that everybody's faces are bigger here. So the Legal Aid Society provides free legal services to people who are eligible. That comes with a trade-off. When you're free, you have to find some way to make it so that you're not serving everybody, because you couldn't possibly ever do that. So the way we do that here with the Legal Aid Society is we have eligibility criteria that tells us who we're allowed to provide free services for. For businesses, that means that a majority of the ownership, so more than 50% of the ownership, have to be people who are eligible for our services. So if you've got a majority stakeholder who is, for their household, 200% of the federal poverty line or below, then that company can be eligible, presumptively eligible. we got to make sure that they fit into our other criteria. So for example, if you've got a business that would be illegal, we would have to say we wouldn't represent you. It's not a guarantee of representation, but at least means that we can go into that next step. The other way that it can work for us is if it's a social enterprise or a nonprofit, we can look at whether the people that you serve are primarily people who would be eligible for programming. So if you were trying to open a daycare in a low income area and you're going to be accepting Title III, Title 20, or if you are trying to open a grocery market in an area that's a food desert, things like that. That would mean that you're setting up your business to serve people that are in the population that we serve, and that lets us be able to help your business. The way I like to look at that is the free legal services that we provide are kind of like an investment or kind of like a grant to the business. If I can give a company $1,000 of free legal work, then that's $1,000 that they can put into their idea. And that works really well if there's somebody who doesn't have a lot of money but has a great idea that is going to be very successful. That's like giving them some startup capital, or if it is a nonprofit, it's almost like giving them a grant to get work in there. And I see a question here. Please explain more on personal guarantee in regard to the liens that could be put onto someone's home. I'm going to go ahead and take this one, Selena. I was thinking about offering it to you, but I deal with these liens on homes all the time. So with a personal guarantee, it means that the contract is not just with the business, but is also a contract with the person who gave the guarantee. So let's say Selena and I have a company, we get a contract, and I sign it, and I also sign the personal guarantee. That means the people I have the contract with can sue the business, but they can also sue me as the person who holds the guarantee. Give me a second to plug this in. I got the low battery warning there. So if they sue me and they win, that gives them a judgment against me. Now, normally with a judgment against the LLC, they wouldn't be able to garnish my wages from an employer. So let's say I start this business while I work with the Legal Aid Society. Turns out Selena and I work really well together, and I'm going to have a side gig with her in addition to working for the Legal Aid Society. That judgment against me as personal guarantor would let them send a garnishment order to the Legal Aid Society and garnish my wages. And it would allow them to file a certificate of judgment with the common pleas court that would give them a lien on my home to the extent of the judgment. So basically, a personal guarantee makes it so that the person I have the contract with that I signed the guarantee on has every right against me personally that any other person that I owe money to would. Without that personal guarantee, if it was just a contract with the LLC, they could sue the LLC. They could get a judgment against the LLC. They could maybe take every bit of money the LLC has. But they couldn't take my wages from my other employment. They couldn't put a lien on my house. They couldn't try to seize my car, any of those things. And maybe Selena and I could go, oh, they've got this judgment. With that judgment, we could work, but all the money that we pour into this, all the money this business makes is going to end up probably paying that judgment creditor. It's not worth it anymore. Let's shake our hands and wrap this business up and go on home. Now, whether Selena would be liable would depend on whether she had also signed the personal guarantee. So a really good seller would make both owners of the LLC sign a personal guarantee. But Selena's still a law student. I figure even with my student loans, I'm the one who probably looks more creditworthy right now because I've got a full-time job. I'm not a student. So maybe they just go, well, we need yours, not also hers. In that case, I'd be personally on the hook, but Selena wouldn't. But if they were really doing a great job, they'd have us both sign a personal guarantee. Because if you might sue somebody, you want as many people to sue as you can and as many people that you can collect against as possible. Whereas on our part, we're doing everything we can to make it so that it's just the business signing up for that and not signing a personal guarantee. Now, the other stuff we talked about before guarantee, that would come in, say we break a contract with a company, or this happens more often when you've got tort liability. So some kind of negligence or something else that you did wrong that wasn't breaking a contract with somebody. And they sue the company and they say, and I think they're running that company in a way that makes it so I can pierce the corporate veil. That's when we get into them proving that we don't have that formality and capitalization and use so that the company is just an alter ego and they can sue us personally. But that's a lot more work for them. The benefit of a personal guarantee is I signed, yes, you can sue me and you can sue me personally and that's fine. And somebody doesn't have to go through all that work of trying to pierce the corporate veil. They don't have to prove that they're entitled to it because I'm doing something wrong. They just have to show that I signed a guarantee and said that they can sue me. So that's really the benefit of that personal guarantee. And why I'm not a big fan of giving it up without getting something for it. Because if you're gonna, business is all about risk. If you're going to take certain risks, you should get certain rewards for it. And you don't want to take risks that you don't know what you're getting, or you're getting something that isn't worth it. Yeah, that's a super good question. Those end up being complicated questions. But that kind of thing is exactly why businesses like corporations and LLCs got started. Is that something that you've ever gone over, Selena? I love giving people history lessons, but if you could say it in a shorter way, I'd go for it. So corporations as an idea got started back in the days of colonialism. I mean, the days of like British Empire colonialism. The first corporation I can think of was the British East India Company. They're famous for all those folks in Boston dressing up and throwing their tea in the tea into the harbor. That tea was all owned by the Dutch East India Company. And the whole way that got formed was, it used to be if you were, let's say you're a group of people sitting in a coffee shop in England, and it's 1502, and you say, you know what, fellas, because they're all fellas at this point, they weren't even letting women walk in there and talk about it no matter how much money they had. Say, fellas, what we ought to do is we ought to put our gold together and hire a ship to go to India and get a bunch of spices and bring it back here, and we'll sell the spices and we'll all be fabulously wealthy. So you say, okay, we'll do that. And then you'll make deals. You're not going to sell the spices yourself. You're going to set up deals with merchants to get that product as soon as it comes in. And they're going to go sell it because you're a rich English person who, a rich Englishman who likes to sit at your country estate. You're not going to sit, in a market stall down by the fish market and have to smell rotting fish all day. So you go and you contract with a bunch of different merchants with stalls. You say you're going to get a barrel of pepper and you're going to get a pound of saffron and all of this. So they've given you money and they're expecting these spices. 8 months go by, and then somebody reports the ship was lost at sea and sank in a storm. Well, all of a sudden, all those merchants you made those contracts with are going to come to you and want their money back. They're going to sue you for breaking that contract because you can't deliver the spices. You and all your friends you made that deal with. That stinks because if you've probably already spent their money, you're a rich, probably landed Englishman So they're going to try to take your country estate that you like to spend all your time at because you no longer have their money they gave. That's a big problem. So they came up with the idea of a corporation that said, okay, what we're going to do, we're going to put our money together and we're going to get a charter that says that we've got a corporation. At the time, you got it from the king, which is why we still have to do it through the Secretary of State. You got to go to the government to get it. And that charter says, here's a separate person. This company is completely different than all the people that put money into it. And when that company hires the gets the ship and sends it over and makes all those deals, makes that money, and the ship sinks, the merchants have to sue the company. And so you're only on the hook to the extent you made an investment into the company. So maybe say you all put 50 doubloons. I don't really know what old timey money is about, but 50 doubloons sounds like a lot. You all put 50 doubloons into the company. Everything is lost. It sinks and everything is lost, and the merchants go sue that company. You're out 50 doubloons, but you're out 50 doubloons that you already paid in. It's an investment. You didn't gain anything, but you're not losing anything either. It's kind of a wash. And that's exactly why we created corporations and limited liability. Because once you create that vehicle for people to put that money in, it means that people with money aren't just sitting on top of it. The idea is they're not just sitting on top of it like they're a dragon and it's their hoard of gold they're sitting on. The idea is that they're getting that money out circulating. And because it's relatively safe for them to do that, because they might only lose the bag of doubloons they handed somebody, not a big old chunk of their hoard. Now, there's some questions about whether that theory all still operates correctly, and I think we can all look at Elon Musk and go, I wonder if that's really working. But that's the theory. Okay. Well, I don't see any more questions in the chat, and everyone just had to suffer through sober history. I know drunk history is a very popular show on YouTube, but I don't know that sober history from a guy in his office is nearly as interesting. But I think that about wraps it up for us, unless anybody else has anything they want to add.
Paul, can you guys hear me?
We can.
Okay, thank you. I would just again like to thank you for presenting for us today. And I'm sure the information was informative, and hopefully we can get some additional participants with some of the additional series. I know Mr. Moses, as well as you, are very experienced in the legal side of things, and small businesses need to really take advantage of this free information that's out there. So, again, I just thank you from the City of Columbus Mayor's Office of Diversity and Inclusion. And if there's any additional series or topics of discussion that you would like to present or that you think would be informative for our small businesses, please definitely let me know or coordinate it with Miss Rhonda Watson Barber, and we will get some additional businesses on here to take advantage of these wonderful services.
Well, thank you so much for having us. It's a wonderful thing that the mayor's office is doing with the Office of Diversity and Inclusion. It's spectacular for Columbus, and we're glad to be able to be part of it. And we'll definitely be in touch with more resources we can do. Anytime I do a Facebook Live, it seems like I don't get anybody during the day, but people watch the recording later. So I figure lots of people will end up seeing this not in real time.
Yeah. All right. Perfect. Thank you. And Rhonda, did you need to say anything else?
No, I encourage people to go to our website, ohbdc.org, to find out about upcoming events that are scheduled. And Ambrose, do you briefly want to talk about, because lawyers talk a lot, will you briefly talk about what you're doing on Friday?
Yes.
Briefly.
Real brief. So as part of Central State University, we have programming to address some of the disaster preparedness for small businesses. And so we talk about the the business continuity plan, which is part of the preparation for small businesses to be prepared to respond to emergencies or disasters that they may face. And we'll go over some of that during the session on Friday.
Thank you. And you can register again at ohbdc.org or increasediversity.eventbrite.com. increasediversity.eventbrite.com. And with that, thank everyone for coming out. As I'm looking out my window, the sun is shining. So let's get out and get some vitamin D and enjoy the sunshine. Thank you, everyone.
Thanks. Bye.